stand by while NCLA cuts through the noise to signal abuse of administrative power. This is Administrative Static with Mark Chenoweth and John Vecchione.
Welcome back to Administrative Static. Mark Chenoweth and John Vecchione with you. And we are pleased to have with us, fresh off of a victory in the U.S. District Court for the Eastern District of California, our colleague, Dr. Greg Dolan, Senior Litigation Counsel here at NCLA. And Greg, we're delighted to have you on the show to talk about Høeg v. Newsom. This is the case where NCLA represents 5 doctors in California suing Governor Newsom and the Medical Board of California and other relevant bureaucrats out there over Assembly Bill 2098. This is the bill that would allow the Medical Board of California to discipline physicians who disseminated information regarding COVID-19 that departs from the quote-unquote contemporary scientific consensus. So this case was argued this past Monday, and then the decision came out just a few days, just a couple of days later, I guess, really. So tell us, this was Senior Judge William Shubb of Eastern District of California in Sacramento. Tell us what the decision held and why it's important.
Thanks, Mark. Thanks for having me. It's nice to be back here. So as you said, we've challenged this statute that went into effect January 1st. The statute makes it unlawful, makes it unprofessional conduct, subject to potential loss of license for physicians to disseminate misinformation, which the statute defines as false information contrary to contemporary scientific consensus.
On COVID
and COVID only. During the argument, the judge actually asked the state attorneys several times to give him an example of what's kind of inbounds and what's out of bounds, what is misinformation and what is not. And all the state could say is that, well, it's fact dependent on any given case. We can't tell you absolutely nothing beyond the fact that saying, if a doctor says that given your prior history of anaphylactic shock, you might die from this, that's inbounds. If doctor says vaccines have microchips, that's out of bounds. But everything in between, they said, we just don't know. And the judge was very concerned about it, and the opinion ultimately showed it, that he said the statute is so vague, nobody knows what contemporary scientific consensus is. Nobody knows how contemporary it has to be last month, last year, 2 years ago. Nobody knows what consensus is. He specifically said, does it mean we as doctors or scientists or government officials or some sort of combination thereof? Only in California, only in the U.S., international, et cetera, et cetera. He actually has an interesting, very long footnote saying, takes up almost an entire page, saying some courts have called consensus what the American Medical Association has said. Some courts have called consensus what the governors of various states have said. Some courts have cited international medical bodies. So he says this term has no accepted meaning. And that makes it very difficult, of course, for physicians to know what they can and can't tell their patients.
Yeah, absolutely. And there were really more than one constitutional problem with this law asserted by NCLA. There were the First Amendment problems, including the fact that this was clearly viewpoint, or it wasn't viewpoint neutral. You were allowed to say things that toe the government line on COVID, but you couldn't say things that didn't toe the government line. Well, that's a First Amendment problem right there. But the judge didn't reach that issue in particular. He really focused on this vagueness issue that you were just talking about. And I guess that's, would you characterize that, Greg? Is that both a First Amendment and a 14th Amendment due process issue? I think it's a little hard to parse that from the decision.
I think I would agree with that. I think there's both a First Amendment issue and a 14th Amendment issue. The judge, at oral argument, which was done by our very able counsel, Janine Younes.
Yes, who's on vacation.
She's on vacation.
Resting. That's why she's not here.
Well-deserved vacation in California. But so the judge was actually asked, he tried to push her. He said, well, you say it's only going to be used against people who like poo-poo COVID vaccine. But what if actually somebody wants to be being even more pro-vaccine than the government? Couldn't the law be used after that? And Janine actually answered quite correctly. She said, it doesn't matter. Whenever you say any deviation from government line, whether you're more pro-vaccine or more anti-vaccine or more skeptical or less skeptical, that is still viewpoint discrimination. It's still a problem. And so the judge took, I think, at least on the bench, took it to heart that that's true. Ultimately, he decided it's not necessary to reach that viewpoint discrimination issue because it does have some additional nuances. And so he rested his opinion on vagueness. But I don't think that means he doesn't buy our argument about viewpoint discrimination or content regulation.
No, it just means that he's being a good judge and only reaching what he has to reach in order to render the decision.
Correct.
And now there was another decision.
I'll just add,
Sure.
Shubb is a very old judge. He's been there a long time. He's been reversed by the Ninth Circuit. He's been upheld by the Ninth Circuit. And that's the other thing I think is on his mind. I'm going to do right down the line what will be affirmed.
Yeah, that could very well be. And that plays into what I was getting ready to say, which is there was another decision previous to this in another district court in California. Was that in the Central District of California?
It wasn't a Central District, although I always get confused which one is which. It's weird to think of Los Angeles as central in California, but it wasn't a Central District in Los Angeles and by Judge Slaughter, which went the other way.
On this same vagueness issue?
On the same vagueness issue. Actually, that opinion rejected both vagueness and First Amendment challenges. Judge Shubb, our judge, did reference that opinion, and he said that, of course, he's not bound by it because they're both district courts on the same level. One is not higher than the other, but also he called it unpersuasive, and I think correctly so.
Sometimes it's good to have an older judge who isn't, isn't afraid to.
I must say
his own
that
opinion.
Judge Shubb was 84 years old. I want to be as lucid and clear and amusing at 46 as he's at 84. He was very good. He read all the briefs. He read all the amicus briefs. He was really on top of both the scientific arguments and the history of COVID evolution. At one point, he actually said, when we're talking about scientific consensus, he's like, what is consensus? He's like, I remember at the beginning, we were told not to use any masks. Then he said, we were told to use 2 masks. And both of those statements came from the same person. So how are we to know what scientific consensus is? So he was really on top of not just legal arguments, but actually the history of this litigation, the history of what led to the enactment of this bill.
And I want to take a minute to recognize our clients, Doctors Høeg, Duracetti, Cariotti, Mazalewski, and Katibi, because if not for them stepping forward to agree to sue Governor Newsom and these other defendants, NCLA wouldn't have been able to bring this case.
And that takes a lot of courage because most, or if not all of them, were attacked on social media. Other doctors said, we can't wait for this bill to go into effect to refer you to the board to get your license yanked.
They wrote to him. They sent emails.
They sent emails. It was just a complete vilification campaign. And the state of California, instead of just saying, okay, you can say whatever you want on Twitter, but we let doctors say whatever they want to their patients as long as it's backed up by their own understanding of science, just got on board and said, yes, we are going to try to yank your license away.
One of the things that was very persuasive to me when we were thinking about taking this case is the fact that, because I come from a medical family, and when I think about the doctor-patient relationship and the fact that people need to be able to trust their doctor, they don't want to think that their doctor is spewing a line from the government. They want to think that a doctor is giving his or her advice based on his or her medical training. Right?
No, that's exactly right. And I think that was part of the problem with the state's argument. The state said, well, it's okay to tell somebody if you had prior anaphylactic reaction, maybe vaccine is not good for you because you run another risk. What the state was missing, though, is that every medical decision, every advice the doctor gives is a cost-benefit analysis. Doctor, somebody can say, should I get, chemotherapy for cancer? And the doctor can say, well, there's cost and benefit, right? You might cure cancer, but you may not live that much longer and the quality of life is going to be poorer. And some people will say, I still want the treatment. Some people say, I would rather live whatever time is remaining for me, with higher quality of life. There's not necessarily a right answer. But the state thinks that there is one. That there's for everyone except perhaps people who will die. There's the right cost-benefit analysis, and there just isn't.
Sure. One of the issues in
I
this,
think we should mention you use doctor, but he's not like a doctor of education.
no,
He
no,
went to
no, he's
medical
not.
school.
This isn't Dr. Jill Biden. This
Yeah,
is,
exactly.
yeah, no, Greg's an MD. So it's great to have his medical insight as we're working on cases like this. It was great to have you out there. As you said, our colleague Janine Eunice argued the case, but you've been the second attorney on this case all along, and we're out there in California as well. Another issue in this case was standing. The question is, no one has prosecuted our clients yet. So why did they have standing to bring this case?
So, well, it's not a surprise that nobody has prosecuted our client. We, in fact, filed this case, I don't remember the exact date, but either late November or early December. And we asked for a very short hearing date. We tried to get a hearing on preliminary injunction in mid-December, before the law went into effect on January 1st. For a variety of reasons, some of the judge unavailability, some of our unavailability, some because the state wanted additional time to respond. It got pushed by about a month, and so we only argued it on Monday. So we wanted to do it right before Christmas. We argued it on Monday. So, but the law has been in effect for only 3 weeks. So it's not a surprise that nobody has been prosecuted. Although, of course, we don't know. For all we know, on January 2nd, the board has been flooded with complaints about our doctors. Until it's published, we don't know. And so the reason they had standing is because there were real threats. When the law was being considered, everybody was saying that, look, just wait till we actually enact it. And it was a real threat. There was a real worry as to what they can and can't say to their patient.
Fantastic. Well, thanks for being with us on this, Greg, and thanks to Judge Shubb for doing the right thing here and granting the preliminary injunction. Presumably, the state of California will appeal this to the Ninth Circuit, so we'll have to see what happens. We'll keep you informed here on Administrative Static what happens in Høeg.
So what else? Welcome back to Administrative Static, and I am joined by our colleague Sheng Li, who helped write an amicus brief in the case of state of West Virginia versus the U.S. Department of the Treasury. We sometimes call it West Virginia v. Yellen because she was tasked with trying to save this unconstitutional section of a bill. And we just got a decision from the 11th Circuit, and the states that sued the government to say that the part of the COVID relief bill that they, if they took it, they couldn't cut taxes. I'm really shortening it up, but that's kind of it. That was unconstitutional because the spending power didn't let them commandeer the states. Now, I am just giving you that thumbnail, and Mr. Lee here, Sheng, you have to correct me if I've really blown it. But tell us why'd we put an amicus in this brief, and do you think it helped?
Thanks, John. Yeah, I think our amicus really helped. And just to give the listeners a bit of background, so in the beginning of 2021, Congress passed a COVID relief bill of about $2 trillion. Of that amount, about $200 billion went to state governments. It was a kind of an offer they couldn't refuse. It was a lot of money, but they all had to agree to a condition if they took this money. And the condition was, if you take this money, you cannot, and I'm going to quote here, you may not directly or indirectly offset a reduction in the tax revenue of such state resulting from a change in law, regulation, or administrative interpretation. So the question is, what is a direct or indirect offset of a reduction in tax revenue? The strong interpretation of this is you can't cut your taxes. It's not just you can't use the federal money to pay for a reduction in taxes, say in your education funding in some way, where you reduce your tax and reduce federal education. But because money is fungible, any amount of reduction in spending or taxing anywhere can be made up for by the federal money. And so that's the interpretation that's been offered on this. It basically says you can't, no state who takes this money can cut their taxes. So what happens? A lot of states.
And Sheng, let me just interrupt you for a second. For a lot of states, sometimes some states have very high property taxes. Some have no income taxes. Some have high sales taxes. There's a whole mix of taxes. And if you felt that any of your taxes were out of whack, COVID or no COVID, and you wanted to fix that, arguably this could stop you from fixing an imbalance in your tax structure that you've been arguing about for years.
Oh, yeah, definitely. And so a lot of states sued in a lot of different courts, actually. And many courts have come out with decisions here and there, some saying the states didn't have standing because they didn't have a concrete tax reduction plan that would violate this rule. Others have found kind of split the baby. But the 11th Circuit came out with what we believe to be the strongest repudiation of this law. And first, on the standing problem, a lot of courts were divided on this. For example, in the 8th Circuit, said Missouri didn't have standing because Missouri was challenging just the strongest interpretation of the regulation of the statute, basically saying Missouri was saying, "Are you telling me I can't cut taxes? That's clearly unconstitutional." And the 8th Circuit said, the Treasury said, well, that's not our interpretation of the statute. We're going to interpret that more narrowly. And then the 8th Circuit threw that out. But of course, when Treasury said we're going to interpret that more narrowly, I don't know how you can interpret that more narrowly. What does it mean to indirectly offset a reduction in net tax revenue? And that's the issue the 11th Circuit took up. The 11th Circuit.
Sheng, as we always talk about all of these deference ideas, if the Treasury now says we don't interpret that way, and then some court upholds it, they could change their mind tomorrow, and under Brand X, they get deference, and it wouldn't matter, right?
They would say either way, exactly. And so what the 11th Circuit said, well, that's not enough for us because one, the injury that the 11th Circuit seized on is the fact that the interpretation of whatever an indirect offset is just ambiguous. It's not ascertainable. And the 11th Circuit said the states, when they agree to a federal spending condition, they have a right to agree to an ascertainable condition. And they analogize this to a contract. Like if you and I sign into an employment contract, and you said, yeah, come in to work for me, I'll pay you something. I have a right to know, well, what exactly are you paying me on an hourly or monthly or whatever basis?
And the other thing is, Sheng, right there, they also said that they found the Ninth Circuit's ruling on this very persuasive. And I was like, boy, you don't see that every day.
Yeah, precisely. So what happened in the Ninth Circuit, Arizona sued, got bounced on standing in the district court, went to the Ninth Circuit, and the Ninth Circuit said, wait a second, Arizona has a right to know what it's signing up to when it took in this federal money. And you can't, what does it mean to indirectly offset? If indirectly offset doesn't mean you can't cut taxes, period, then we don't know what it means. So there, the 11th Circuit said that was enough for standing for the states, which is West Virginia and about 12 other states. Notably, the 11th Circuit's decision on standing diverged from the 6th Circuit decision on standing. The 6th Circuit there were 3 states in the 6th Circuit. The 6th Circuit ultimately said Tennessee had standing, but Ohio and Kentucky did not, because Ohio and Kentucky didn't specifically say they intend to violate the Treasury regulation. They merely said they intend to violate the statute. And the 11th Circuit said, well, wait a second, an agency can't cure an ambiguity in the statute by issuing a regulation. And that's the argument that NCLA really, strongly advanced before the 11th Circuit. The state's brief had about a paragraph on that. None of the other amicus had an argument on this point. But NCLA spent, many, many pages on it. And the idea here.
No, go ahead.
Go ahead. The idea here is the Treasury said, wait, well, we understand maybe this indirect offset language in the statute, it's hard to understand what it means, but Treasury comes to the rescue. We wrote a regulation. Treasury wrote a regulation that more narrowly defines what an indirect offset is and when an indirect offset occurs, such that Treasury can come and recoup funds from the states. We think those regulations weren't very good to begin with and weren't very clear, but more to the point, if the statute is, the rule is the statute has to be clear so that the states know what they're agreeing to. But if the statute is unclear, if you can't figure out what the statute is, what indirect offset is, then for Treasury to come in and impose its own condition, then that condition isn't a condition that Congress is imposing, because Congress didn't say anything clearly. That's a condition that Treasury is conjuring out of thin air, really. And the court seized on that and said an agency can't cure a standardless, statutory condition by adopting its own limited construction.
Because also that would be Treasury imposing a deal on the states that the states didn't accept. And Treasury certainly doesn't have that power. I don't think Justice, there is nobody, even a strong administrative state advocate, that I think would say that the agency has the independent power to do that. So, I mean, that's a non-starter, I really think. And the other thing here that I think we will be using again and again on standing, it's always been the law, but I thought they were very clear on it, is you could sue with a bunch of people, and if one of them has standing, everybody goes through and we decide the issue, which I really loved.
That's right. And here was West Virginia led the way, but there was 12 other states, and the court said, well, Kansas has standing under this theory, and North Carolina has it under that, and that's enough. We don't really have to look past that, anything else, because all the states are otherwise in a similar situation. And back to this idea that an agency can't cure an ambiguity. Certainly, the court here, decided the case that was about a spending clause condition imposed on states that was ambiguous. But to the court's point, didn't get into it. But I don't see why that logic doesn't extend to other statutes, including ones that regulate individuals. If a rule is ambiguous, why is it that the agency gets to invent its standard rather than having the rule fall because it's too ambiguous?
Yeah, I think there is that. Although I guess what the other side would say is that, hey, they're allowed to fill gaps, that Congress has given them that power, and there's no independent sovereignty on the other side facing them like there is with the state. I think that's the argument.
Yeah, and I think that argument gets only so far, because I think it depends on whether there's already a pre-existing clear statement requirement. And for the spending condition, there is a pre-existing spending clause requirement. And as some of our listeners might know, there's also a pre-existing clear statement requirement for criminal liability. You can't have ambiguous criminal law. And so that in our bump stock case was one of the reasons why the Fifth Circuit said, well, the agency doesn't get to come in and invent its own, definition of what a criminal liability looks like.
Yep. And so in this case, once again, the states have states attorney generals and solicitor generals and all these people have defended state power here that the senators didn't defend, and that the Congress didn't defend. And I think it's the correct outcome, because it would have allowed the federal government to direct the states to do anything at all if you take federal money. And that, I mean, even how you spend your budget, how you raise your taxes and how you spend your budget is the core of the state sovereignty. And that this would really threaten that.
That's certainly an alternative ground that we advance in our brief, which the court didn't get to because it found it to be unconstitutionally vague. But if you think about it, the federal taxation power is vast. What the federal government can do, and in fact it does this, is just enact very high rates on the citizens and businesses of each state, takes that money, remits part of the money back to the states and say, we're buying your acquiescence to whatever we want, including, control over your own tax policy with money that we took from your own citizens.
All right. Well, thank you for being with us, Sheng. That music means it's time to go. Appreciate it.